Good afternoon, everyone. My name is Dr. Sanjay Deshpande. I am an associate professor here at KLS IMEI. On behalf of the Institute and NDLI Club and library in particular, I welcome all the viewers to this online session on the title Copyright Act for E-Resources. It's quite a challenge for me to talk on this topic because I know I'm talking about an ocean, and when I am talking about an ocean, I should also have an ocean of knowledge. However, I will try my best to throw some light on the issues pertaining to copyrights, e-resources, what ways can you access the information that is hidden and stored in e-resources, e-folders. So let me start my presentation now. I have a few slides to share with you all. I request your attention, and I'm sure at the end of the session you will have some takeaways. The basics of it will be understood by you. So talking about copyright, let me move my slides. Slide is disappearing. Friends, we all know something revolutionary happened in the early 2000s. I'm talking about IT revolution in India. With IT revolution on a expansive drive, information available in the internet resource became accessible to one and all. Of course, it was advantage on one hand. On the other hand, it was an Achilles heel. It was a pain area for people who had given their heart and soul to an article, to a story, to a research paper, to some content that they had written out from their noble thoughts and with their creative ideas. Because this was subjected to piracy and it was easily available for theft. It was easily available for plagiarism. There was some need, there was some sort of security for these resources that were bundled in the website. Slowly, virtual libraries were established. By virtual libraries, we mean the storage spaces where important information was stored. E-libraries give access to electronic format of thesis, electronic format of research papers, e-journals. After 1991, we all know, I know I am going back in time to 1991, after the LPG era, where there was physical movement of goods and services across national borders. After the web world was connected, there was intangible, unseen movement of electronic resources across the globe. And there was a dire need for people to have some sort of consortium, some sort of regulation, some sort of framework to know what to enter, where to enter, what not to enter. So some sort of regulation was necessary, because this was causing a lot of economic loss to the original authors who had written stories, who had written dramas, who had written screenplays and so many other things. Then came the act of Copyright Act 2016 amended. Originally this act was enacted in the year 1957. This is one such act which has undergone multiple amendments, and the latest is in 2016. The primary motto of this act is to provide a shelter or safeguard the interests of original contributors who have given their intellectual resources to the literary world. Let me continue my presentation. So talking about a few important terminologies. talking about a few important terminologies associated with Copyright Act 1957 and then amended in 2016 are as follows. The word publish. This word is very common and most applicable to academicians. Publish. We all know that there is a lot of craze to publish case studies, articles, research papers. So the very meaning of publish is to present some information in the public domain or for public use. So you contribute your noble idea to the general public or to the public at large, which will in turn be useful for them. This word is called as publish. This can be for academic purposes, this can be for knowledge sharing, or this can even be to generate jobs. So the information what you publish is in public domain and for the public use. So that is publish. The next word that we hear or that we get to know when we read Copyright Act is copyright. So what is copyright? It's a form of legal protection given to creators of original authors or original work of authorship. So copyright is like a shelter, it's like a cage given to literary contribution of original authors, which is subjected to protection and which hackers, which people cannot directly access. They will have some limitations to access this information. So it's a kind of shelter, it's kind of a cage that is put around the information or which is put around the original contribution of authors. Then copyright infringement. When we read Intellectual Property Right 2000 and we read Copyright Act 1957 and amended in 2016, we get to hear this term copyright infringement. So what is copyright infringement is violation of exclusive rights. In case I happen to steal somebody's intellectual property, somebody's idea, somebody's original contribution, I am infringing upon the copyrights of the person, provided it is copywritten in some form, in a tangible form, in a form of CD, in a form of a registered article, in a form of licensed copy. So when I infringe upon somebody else's work which is documented, which is registered, which is copywritten without the due permission, without obtaining the due permission of the original author, original noble worker, that is called as copyright infringement, where I steal the data without the awareness of original contributor. So that is copyright infringement. When I talk about intellectual property, a very important component, especially in the internet world, especially in the IT era, intellectual property basically refers to creation of mind. Intellectual is cognitive ability, and the property generated out of cognitive abilities of people is called as intellectual property. It can be copyright, it can be patent, it can be a trademark. So intellectual property rights are invisible to the naked eye, but then they can be registered, they can be documented, they can be stored at a place, and they can be of commercial value to the original contributors. Then I talk about license. License is obtaining permission to use the existing information for some creative use. It can be for translation, it can be for republishing. In case a researcher has found out that the original contributor or original piece of work lacks something or has some shortfalls, so with the permission of original contributor, I can publish this data back again in the public domain by obtaining the permission for editing the original document, or it can also be for translation for a wider use. So that is for license. So all these are pertinent issues, pertinent terminologies as regards Copyright Act is concerned. So when I go to my next slide, I want to talk about 3 golden rules of copyrights. There are 3 golden rules of copyrights. The first one is originality, second one is creativity, and the third one is fixation. When I talk about the first golden rule, which is originality, Copyrights Act 1957 lays a lot of emphasis, lays a very strong foundation on originality. It encourages original work. It encourages noble work of the first contributor or of the first author. It can be a story, it can be a research paper, it can be a drama play, it can be an artistic work, it can be anything. Copyrights Act gives a lot of emphasis on originality, so that is the first golden rule. Second is creativity. In case you want to bring about or you want to bring in a lot of creativity to the existing piece of information, or you want to have a new novel piece of work, that is the next area that Copyrights Act gives a lot of emphasis on also. So creativity is either you improve the existing content or you come up with something which is very novel, unheard, unprecedented, and that adds to the existing literature, that is called as creativity. The next golden rule is fixation. Imagine an original author, the first author, has given out his piece of work to the literary world. Fixation basically talks about fixing up in a tangible form, meaning you get a physical certificate of copyrights against your name or registered against your name. This is fixation. So Copyrights Act gives importance, lays emphasis on fixation. This is the third golden rule, where the original contributor is authenticated for his noble work, in the field of music, in the field of cinema, in the field of academics, in the field of arts, anything, any area. He has to have some physical proof which is tangible. We are talking about a copyright certificate when I talk about fixation. So these are three golden rules of copyrights. So when I go to my next slide, talks about what are the major provisions and what are the major prohibitions of Copyrights Act. The first provision is it protects the rights of original authors and writers, which I have already explained. On the contrary, it prevents plagiarism. It prevents unlawful, unauthorized access to the existing literature, which is somebody else's work, which is somebody else's intellectual property. The next provision that Copyrights Act focuses on is to perform work in public space or to communicate some information for the benefit of public. This can be for the purpose of information exchange or knowledge exchange. As I was mentioning before, Copyrights Act gives provisions in the field of literary works, dramatic works, musical works, artistic works, cinematography and sound recordings. All these are intellectual properties which cannot be purchased directly in a retail shop, in a market space. These come out only after somebody puts out their intellectual piece of work, somebody puts in their intellectual labor to generate these intellectual assets. Hence, Copyrights Act gives a lot of reinforcement for these works or for these original contributions. Then intellectual property right prohibits, Copyrights Act prohibits unauthorized access to protected property. It also prohibits the people who want to have pseudo claims as original authors. This is another form of stealing. This is becoming a disguised owner or a wrongful owner of somebody else's property. So Copyrights Act 1956 puts a lid on all such unlawful practices to prevent stealing of information stealing of intellectual property, and it encourages or safeguards original piece of contribution. And the other provision that Copyrights Act 1956 as well as 2016 gives is, it says copyrights can be transferred upon your own willingness, upon your free and genuine will, you can transfer your copyrights. And for the information of all the viewers here, copyrights last for 60 years from the date of registration, and upon the death of original contributor they run for another 60 years. So going to my next slide, what are the ways in which you can get access to the information which is under copyrights, with copywritten material, copywritten content? There are various ways in which you can access the copywritten material. One is the permission. You can write to the original author. We all know that in a globalized era, we can connect and we can get access to people across the globe. In case you come across the original author, you can write to the original author seeking permission or to seek his permission to use his content, and you will have to mention for what purpose are you trying to get access to his information. In case the usage is for commercial purposes, then you may have to pay royalty to the original author. In case the access is for academic purposes, then the access may be free of cost. So it all depends upon how author aims to provide or aims to read your email, and it is his intellectual property, so it is his prerogative, it is his discretion to provide access or to provide permission. Registration. Friends and viewers, you may have seen that when you land up on a specific website or n number of websites, they always ask you your email ID, they always prompt you to register your names, your designation, your affiliation. The reason is very simple. Instead of anonymous viewers, they want to know who is the person trying to access this information and what is the purpose for his endeavor of getting access to digital content. So registration using your official email IDs or personal email IDs as well. So permissions will enable or help the original contributor or a publishing house to know why is the information being accessed. Then the next way to access is to get license. Alright, license, as I said before, is to republish the data in case you want to add on, you want to edit the data and you want to upgrade the information, you want to update based on your research, you want to contribute, you want to add on your intellectual ideas to the existing piece of information, probably to plug the loopholes or to overcome the lacuna, or you want to translate the information so that the existing piece of information lying in some cubicle, unseen cubicle, can be utilized by people who are in need of it. So it can be for translation as well. These days, when we talk of multicultural context, multi-language context or multi-language scenario, translation has become the need of the hour. So these are some of the ways using which or through which you can get access to digital content. Next, when I talk about some legal frameworks available, and let me tell you that copyrights in India are governed by Ministry of Education under the aegis of Government of India. These are some major consortiums in India which are rule making, regulating, bureaucratic, nodal bodies which govern how e-resources must be dispensed, distributed, disseminated without causing economic or general loss to the original author. AICT and INDEST, this is government funded project or government funded body. Then CSIR e-journal consortium, then UGC Infonet consortium, then DAE consortium, MCIT consortium, IIM Libraries consortium and Forza consortium. These are some of the prominent consortium agencies in India or consortium bodies in India. Some of them seek nominal fee for registration, some of them seek nominal registration fee and access fee to facilitate the original author. Some of them distribute e-resources at free of cost. You will have to read the terms and conditions of each consortium body. The purpose is very simple. The information must be utilized for a constructive purpose, for a bigger cause, to build the nation. As we say in the era of information or in the era of IT, information is wealth. The whole objective of all these bodies that we have spoken about or we have listed here is very simple, that information is wealth and this wealth should not spill over, this wealth should not be wasted like water. That's the whole purpose. Going to my next slide. Okay, one slide back. Yeah. Staying, I'm sorry for that. Staying on the same page, I have one genuine appeal to all the viewers over here. Whenever you land on a website, whenever you surf the data, whenever you get into web space, please make sure that you acknowledge the original author or the original contribution of someone. In case you happen to extract the data of someone, it is somebody's novel piece of work. I request one and all to please acknowledge the original contribution. That is a sign of gratitude for the noble work that somebody has done. At the same time, let us not become the servants of information technology. Let us add on to the existing literature. Let us contribute to the body of knowledge, and let's not subserve ourselves and our will and our intellectual abilities to the world of internet. Thank you so much for your time. I believe that you have got some insights about e-resources and Copyrights Act. Everything cannot be discussed at one point of time. This is an information capsule that I have tried to give to you. Thank you so much. Close.